Hello, everyone. My name is Roland Schroeder. I am in-house corporate counsel with General Electric Company in the U.S., but I manage matters globally and have extensive involvement with the ADR and mediation initiatives, and have been honored to participate in this initiative and program since last year. I will be the moderator of our very distinguished panel. In the interest of time, I'm going to minimize my introductory comments and allow each of our speakers to introduce themselves briefly. But I think our role really is to build on the last program, really excellent discussion about, or all morning about how ISDS is working in practice, how it's addressed in particular to business disputes and the like, and really talk about, I guess, two areas. One is how it may be applied to areas of larger societal issues, societal change, involving a much broader set of stakeholders. And secondly, to start to think about where this might go in the future. So without further ado, and we're gonna I think each try to speak for about 10 minutes and then have some time for discussions. So hopefully this will get everybody thinking about what they want to chat about. Without further ado, I'm going to turn it over to Robert to kick us off.
Thank you very much, Roland. It's a delight to be here. And in order to introduce myself, I am what might be called a practicing academic or an academic practitioner. Never know what's the best term. So I'm both a barrister and mediator, but I'm also a professor of international law and human rights at the University of Nottingham. And I've been working in the field of business and human rights for far too many decades. And I do a lot of advice work for governments, for civil society, for international organizations, for corporations on the kind of issues which arise in relation to business and human rights. But when I say business and human rights, what does that mean? Well, these are disputes which arise when there's a claim about a business's activity which has impacted on a human right or also an environmental issue. But I'm not going to deal with environmental or climate change issues, as Amadine and others will talk about that. So let me give you some examples. A human rights impact can be where a business uses child or forced labor, or when a business causes pollution to the land or water of local communities, or when a business discriminates on the grounds of race or gender in terms of maybe who they buy goods from. In many of these instances, the state is also involved. It could be, perhaps, as has happened in some instances, providing forced labor to the business, or perhaps in reaching a contract with a business over the land which a local or an indigenous community considers it has title to. There's also a current international legal framework. It's based on the UN Guiding Principles on Business and Human Rights and the OECD Guidance on Responsible Business Conduct and the International Labour Organization's Tripartite Declaration. There is also now a growing amount of national legislation and with a very high chance that the EU will introduce legislation next year on this area. Essentially, it's got three elements. The state has a primary obligation to protect human rights, including if it is the business that has acted. Secondly, that businesses have a responsibility to respect human rights, and that respect is both where the business causes or contributes to the human rights impact, and also where it has a business relationship, such as in a supply chain, and does nothing to prevent or mitigate that human rights impact. And thirdly, where there's been access to remedies for victims. Let me show how this can work, where there's this link between the state, business and human rights. There's a case called Araya and Nevson, which came before the Canadian Supreme Court just this year, well, that was decided just this year. In that case, it was claimed that the state, which is the state of Eritrea, had forced conscripted soldiers to work as forced labor. And also the claims would say as slaves and as many other human rights abuses, and working in the Nevson gold, copper and zinc mine in Eritrea. and that Nevson knew this and did nothing and continued to work in a way which abused the human rights of those affected. And of course, part of the argument why Nevson did nothing, it was in a joint venture with the state. And interestingly enough, the Canadian Supreme Court said that it did have jurisdiction to consider the claim against Nevson as a business. But of course, no claim was brought in Canada against the Eritrean state due to sovereign immunity. So that kind of gives a context to how these cases might arise. So why is mediation relevant? Well, what mediation offers, as you all know very well, is to consider these disputes early, before independent persons, and facilitate tough and sensitive discussions. And it's also able, particularly in these kind of circumstances, address power imbalances and give people, particularly local communities, a direct agency in the process and the results. And it can also be alert to cultural issues, which are often completely beyond the scope of most national courts. And in this instances, it might also test the opportunities for consensual outcomes in conflict settings. And in many instances, mediation could be included as part of a business's operational grievance mechanism. However, I know from my experience, there are actually not many businesses who have good operational grievance mechanisms, at least ones which are independent of the company and are being seen as transparent and effective. I worked with one company who was really thrilled about their operational grievance mechanism until it was pointed out to them that that was only accessible through internet, and most of the community, of course, had no access to electricity, let alone, of course, the internet. So what a mediation can do is able to have more than one party included. So it could be the state, the business, the employees, the local community. And this, for example, was a situation, a case involving Montereco Metals, which was brought before the United Kingdom courts against its operations in northern Peru, where the state had, to put it politely, dissembled about whose land the copper mine was on. The local community was outraged that they considered it was its land. And the business then worked with the state's security forces to do allegedly physical harm to the community members. After many years, it ended up in an English courtroom, which led to Montereco being forced to pay a large settlement. When all those parties could have been at a mediation much earlier on in Peru at the start of the dispute. And it also has significant potential benefits in terms of times and cost for all parties, because in almost all instances of businesses impacting on human rights, the dispute often begins fairly early on in the business operations, and then very quickly they lawyer up, rush to a court. But still it takes a lot of time. In the Nevson case, which I mentioned a bit earlier, the claim began in 2008. It took until 2020, 12 years later, for a Canadian court to decide it had jurisdiction. Just to decide it had jurisdiction. The merits have still not been decided. In fact, in that case, the case settled, but we still haven't had a merits decision on the actual instance. So there's huge amount of costs, including legal costs for all parties, and being decided in that case at a long, long distance from where the operation and the dispute began. Now, what I want to do is just give a quick case study as to how it can operate. This is one involving the Centre for Effective Dispute Resolution, CEDA, with which I've been working for some time to develop a facility in this area. And the particular case study involves a group called Bonsucro. Bonsucro is a global multi-staker not-for-profit organization that exists to promote sustainable sugarcane production, processing and trade around the world. There's over 250 members in over 50 states from all parts of the sugarcane supply chain: farmers, millers, traders, buyers, and support organizations. But it was clearly felt it could not handle complaints in a clear manner. And so with the help of their lawyers, they came to CEDA to develop a mechanism. I'm not going to go into detail, just to say there are 5 elements of it. The first is eligibility. And Bonsucro itself checks that it's a proper complaint against the member. And when I say proper, means that it's brought in relation to Bonsucro's membership aspects. And then this is when CEDA comes in for the next 3 steps. Firstly, to gather information. CEDA gathers the complaints from wherever it's come from, could be the landowner, could be the communities, could be the trade unions, and sends it to the member for a response. And for example, could even check, has there been proper certification about the sugarcane? And then if there's no clarity at that level, there's mediation. It's an automatic part of the process, and it's run by a CEDA mediator. And then if the mediation doesn't resolve the situation, there's adjudication by a CEDA adjudicator, who is obviously independent from the mediator. And they make a recommendation, and it can be about a remedy to the complainant, it could be about what action Bonsuco could take about the member, including suspension and expulsion. And the final element is monitoring, and Bonsuco itself monitors the outcome. Perhaps two other elements in the mechanism to mention. There's a clear timetable, so the matter doesn't just drift off and not be followed up. And there are fees which can be paid by the member or the complainant, but Bonsuco itself has a fund to support it. And I think there've also been benefit from excellent mediators on the process, including Wolf, who many of you will know. So how would I conclude from this? Well, it's obviously just one example, but I think it is one which could be replicated and could be extended to situations involving states as well, or even other institutions, such as financial institutions, who are otherwise often waiting years for a resolution to a funded project. And also CEDA, through Karl Mackey, is working to develop a new facility on mediation in these kind of business and human rights instances. And what we're trying to create is a hub and spoke model, where the more experienced mediators, say in the global north, work with locally respected mediators to assist in the process. So we're able to engage appropriately and not just come in as some kind of external mediator who may not know the local circumstances as well. And of course, with all of our experiences online, we're beginning to get used to doing some of these kind of processes. So what we're finding is business human rights are beginning to take a bigger and bigger amount of time, of businesses, of complainants, and that mediation offers a really effective way forward to enable these disputes to be considered thoughtfully and independently at an early stage in them, saving a lot of time and energy and hopefully providing an appropriate remedy for those involved. So with that, I'll finish. Thanks, Roland.
Terrific. Thank you, Robert. Amandine, please.
Yeah, thank you, Roland. Thank you very much for inviting Clan Earth to take part in this discussion. So my name is Amandine Bannenberg, and I've been working at Clan Earth for a bit more than 2 years as a lawyer. So for those who do not know Clan Earth, we are a global environmental law organization with offices in 7 countries. We have more than 200 staff, many lawyers working globally. And we use the law to come up with practical solutions to tackle global environmental challenges. So from protecting forests and oceans, tackling climate change and pollution, to strengthening the rule of law and improving access to justice. So our work consists in changing the system and protecting the environment by engaging in both legal advocacy and litigation. My work specifically focuses on the relationship between trade, investment, and environment issues, with the objective of both addressing adverse impacts that trade and investment may have on the environment, as well as leveraging trade and investment instruments to enhance environmental protection. So I'm therefore very happy to have this opportunity to share Clan Earth perspectives and views on the role of mediation in resolving particular environmental issues that are caused by investors. So in my presentation, I will look at the role of mediation from the perspective of environmental protection. I will first provide a generic overview of the potential limitations to the role of mediation in the context of environmental disputes. And I will then also assess whether mediations can be a legitimate alternative to ISDS from civil society's perspective. So first of all, I think it's really important to flag that mediation in the context of environmental disputes covers a wide variety of factual scenarios with often various specific interests at stake. And such multi-party disputes often deal with complex situations where one needs to balance the use of natural resources and the preservations of those resources for future generations. So these situations are very different from interpersonal disputes and the private context in which mediation emerged in the first place. So to assess the role of mediation in resolving disputes involving environmental issues, one needs to look at the particular characteristics of environmental disputes against the inherent features of mediation. And so in this regard, I would like to discuss three main challenges. The first one, obviously, is transparency. The secrecy and confidentiality of the proceedings and the outcome of mediations can be particularly problematic from an environmental perspective. Most environmental issues arising out of a conflict with investors involve governments and thus broader public interest issues that require public scrutiny and public debates, which mediation unfortunately risks undermining. The second issue is power asymmetry. The asymmetry of resources and powers among the parties in environmental disputes can often be very problematic when the asymmetry is too great. And that's especially the case between companies and local communities or environmental organizations. So from our experience, this power asymmetry has often undermined the possibility for mediation to lead to a solution on fair terms or to a mutually beneficial outcome. Because mediation can allow more powerful parties to impose their will on the weaker parties. It can limit the range of choices for negotiations to the most beneficial in business interest. Or it can also fool parties with less negotiation experience into accepting less favorable outcomes that they could get a court to order. And then third and finally, the outcomes and access to remedy perspective. Definitely communities could appreciate the opportunity to have a facilitated dialogue, to get a seat to the table, to be heard, to receive information, etc. But when it comes to effectively solving a problem or agreeing on a remedy for harm, seeking compensation, well, mediation is not likely to be the appropriate tool, and this for two reasons. First, environmental disputes often involve issues of immense importance to the parties. And these disputes are often grounded in fundamental divergence between the interest and the values that are at stake. And it may be very difficult to compromise through mediation. It's often a battle between short-term profit interest versus broader and long-term impacts for local communities and environmental organizations. And second, companies are often not likely to take mediation outcome seriously if there isn't a threat of a court judgment behind it. They will ignore the outcome if there is no reason for them to comply. So mediation does not really help improving access to justice and remedies in such cases. And to the contrary, mediation could even increase the injustice in the existing system if mediation is used by companies to avoid traditional judicial avenues and thereby limit their liability. Victims and those that are impacted by environmental harm or human rights abuses have often difficulties in having access to remedies, and multinationals get away without liability very often. So this needs to be addressed by improving access to justice and access to remedies, and not by pushing people away from the courts. So to conclude, I believe that mediation can be an attractive tool in certain specific circumstances, as Robert mentioned, especially if it's used at very early stages, to allow people to share information, to listen and better understand each other, especially also when the issue is not ripe for litigation and that the mediator really acts as a facilitator. But in most cases, the role mediation can play in resolving effectively environmental disputes is limited by the challenge I just discussed. So while I can clearly see the advantages of mediation from the perspective of investors, from an environmental perspective and local community perspective, traditional adversarial judicial processes are often the preferred option. And now quickly turning to the second aspect of my presentation as to whether mediation could provide an alternative to ISDS, one needs to clarify again, what do we want to achieve with mediation? Is mediation intended to be used to help investors resolving environmental disputes entirely to their benefits? Or are we trying to advance other objectives of the parties and stakeholders? So from our perspective, the real question is whether investor-state mediation helps addressing the structural failure of ISDS that have led to the current legitimacy crisis. And in this regard, I would like to point to 4 concerns that have been expressed by civil society against ISDS. So transparency, balance and participation, relationship with domestic courts, and the risk of regulatory chill. And I will discuss whether mediation provides a legitimate solution in this regard. So first, transparency. As I mentioned earlier, disputes involving governments must be transparent in order to ensure government accountability and respect of rule of law. ISDS has been precisely criticized for the lack of transparency, as well in the proceedings and the outcome of the case. And it doesn't seem that mediation really provides any improvement in this regard, especially because the Mauritius Convention on Transparency in ISDS doesn't even apply to mediation. Secondly, on balance and participation, that's a second criticism of ISDS, which relates to the fact that the system is clearly tipped in favor of foreign investors. Only foreign investors can initiate the cases. There is often no possibility for states' counterclaims, and affected parties don't even have the rights, sufficient rights to intervene beyond the amicus curiae possibility. In that regard, mediation can offer a forum and a process that is generally a bit more flexible than ISDS, because if it's properly used, it can be adapted to the circumstances of the dispute, and it can help to support mutually beneficial outcomes. But that again requires really to ensure that all the stakeholders are identified early in the process and that the rights and the interests of those that may be impacted are included. But again, there remains some limitation because mediation is, especially if mediation is conducted under the threat of an ISDS challenge. And if the privilege and obligations that are established under investment treaties remain the applicable legal framework. And then third, on domestic court relationship, a third fundamental issue is the problem that there is an absence of requirement of exhaustion of local remedies, and that allows ISDS to bypass national courts and national legal framework that contain important legal guarantees in terms of transparency and public participation, judicial impartiality and independence. Again, I don't see really how mediation can help if it's used to bypass domestic courts and domestic processes. And then finally on the chilling effect, well, ISDS has been very much criticized from civil society perspective for creating this effect because mediation does not lead to binding outcomes. It may be that it diminishes the risk of a regulatory chill on governments, but still it can be used as a forum to put leverage, and be used as a leverage to put pressure on governments. So to conclude, it's clear that mediation does not resolve the fundamental problems around ISDS, even if it provides more flexibility and that it diminishes the risk of regulatory chill. It's only to a very limited extent. And so if mediation is perceived as a way to bypass national courts and democratic rules, ensure non-transparency, and avoid participation of affected third parties, well, I think that mediation is bound to face the same fate as ISDS and will result in the same civil society backlash. So I think we need to be very careful because this would be seen again as an attempt to avoid addressing the real injustice in the existing system and ignoring the need to rather improve access to justice and remedies for all stakeholders and not only for foreign investors. And I will stop here. Thank you very much.
Thank you, Amandine. That was terrific. Brooke, we'll turn it over to you.
Thanks, Roland. And thanks to the earlier presentations of this panel and the others, which are really terrific. My name is Brooke Gouven, and I am a senior legal researcher with the Columbia Center on Sustainable Investment, CCSI. We're a joint center of Columbia Law School and the Earth Institute at Columbia University. And we are a applied research center dedicated to the study, practice, and discussion of sustainable international investment. And one of our key areas of expertise and where I work is on international investment and international investment law and the way that these frameworks impact sustainable development outcomes. And also looking forward to the way that processes and frameworks can and should be shaped to better align with broader development outcomes, including the Paris Climate Change Agreement, the Sustainable Development Goals, the Convention on Biodiversity, Financing for Development Agenda, and many more. So today I'm going to talk about the role and potentially, how investor-state mediation can and should be used in the context of COVID. And I'll echo some of the things that Amandine and Robert have raised, but perhaps from a slightly different angle. But again, I will also touch on and start with sort of looking at this from the framework of existing law, and that is to say international investment agreements and ISDS in particular. So as we all know at this point, the COVID era is having profound health and economic impacts that have yet to be fully realized. And we are already seeing the ways in which government and private sector activity are reacting, adapting to, and evolving under the pandemic. And while these adaptations are ebbing and flowing over time, in some cases are government-led or mandated. In some cases, they're also driven by private sector opportunities and economic interests. But looking particularly from the angle of the government action, many and likely all governments have taken different steps to address the health and economic fallout of COVID. So these include things like closing down non-essential businesses, restricting national and international movement of people, seeking compulsory licenses of essential medicines, temporarily nationalizing healthcare facilities, imposing export restrictions, and suspending the collection of fees in certain areas or sectors such as toll roads. So these changes to regulatory frameworks are taking place within a pre-COVID investment framework, which sets forth the ways in which governments can regulate economic actors and activities. And in many cases, these regulatory frameworks involve one or more international investment agreements, including ISDS. And many steps taken by governments, those I mentioned, and others that governments will undoubtedly take as they try to recuperate their economies, are ripe for challenge under the majority of investment treaties. So even before COVID, ISDS was controversial and suffering from a universally acknowledged legitimacy crisis, at least amongst governments. And while there are many reasons for this, and we all know them, I'd like to just name a few. It's unpredictability and uncertainty, conflicts of interest that can plague arbitrators, the unrestricted shareholder claims for reflective loss, the role of third-party funding in advancing claims, the lack of counterclaims against investors, the impact on the rights and interests of non-parties who can't participate in these disputes, the lack of transparency, particularly as it impacts democratic accountability, and damage awards that are often not available under domestic law. So many of these concerns are exacerbated under COVID, where governments have all taken unprecedented action to regulate and restrict private sector economic activity. And many existing treaties do not have in place adequate or indeed any safeguards to permit defenses to these actions. And I would assert that even treaties that do have protections in place face unpredictable outcomes and thus economic risk in the COVID context. So in response to this unprecedented circumstance, and I feel like I'm using the word unprecedented quite a bit today, many or several globally prominent economists and lawyers have called for a two-pronged approach consisting of a moratorium on all ISDS claims during the course of the pandemic and a permanent restriction on COVID-related ISDS claims. A group of 630 national, regional, and global civil society organizations have echoed this call and have expressed extreme concern about the role of investment treaties and ISDS in the COVID context. Individual countries and regional intergovernmental organizations, such as the African Union, have expressed concern at the risks of ISDS under COVID. And what I would like to discuss before taking a brief detour is whether then we can look to investor-state mediation as a preferable way of addressing the changed relationships between investors and states in this context. And I've raised the above to situate this discussion within the current context of how broader societies are looking at these relationships between investors and states under COVID and disputes that might arise. So before turning to mediation, I do want to acknowledge that as governments are currently restricting economic activity, it's abundantly clear that there will be a critical and essential role for the private sector in economic recovery. And the private sector will be necessary for employment recovery, tax revenue, infrastructure, the advancement of industrial policy, and generally to achieve global development that has now been set back a decade. So when we think about what we want to put into place to build back better, this is really an unprecedented opportunity to align governance frameworks and the rights and powers of the various actors within them with broader development goals. And it is abundantly clear that the existing practice under most investment treaties of prioritizing covered foreign investors above all economic and social actors and placing no requirements on foreign investors in the context of climate change, domestic labor, local content, and other industrial policy goals will not make sense from a sustainable development perspective. So we have to change this framework. So is investor-state mediation the way to go? And if so, how does it fit into this picture? If ISDS is fundamentally ill-suited to address COVID and other claims moving forward, can mediation be a preferred approach? So in some ways, investor-state mediation is an attractive approach, and these were raised by other speakers on this panel, particularly for certain kinds of disputes. So while we see that ISDS is very much one size fits all, that is to say, a dispute concerning a direct uncompensated expropriation or a dispute regarding performance or a payment under a contract, is handled in much the same way that a dispute involving government regulatory action taken to manage climate change objectives or to ensure sufficient hospital capacity for COVID patients, or over a poorly managed consent process of an extractives claim. These are very different kinds of disputes invoking very different interests on the part of the public. And mediation has built-in flexibility that could perhaps better accommodate these complex kinds of disputes, undoubtedly those that will arise under COVID. And particularly, whereas there is an ongoing relationship between the investor and the state, as well as society at large, but one that is now existing under fundamentally changed circumstances, mediation may present the flexibility in both process and outcome that could help each of the investor and the state to set forth and address their needs and lead to outcomes that are mutually accepted by all the parties. And this may be particularly the case when mediation occurs at early phases in the disagreement, where changed relationships have just occurred. So ideally, this would lead to lengthening and strengthening of investor-state relationships and the kind of investment retention and reinvestment that may otherwise be threatened under COVID and other circumstances that is going to be so critical in the coming years. But there are also very serious risks to mediation, many of which have been highlighted in the ISDS context, and Amandine raised some, but I would like to reiterate some of these just in the context of investor-state mediation from a public policy perspective. So there are three major areas that I want to talk about. The first is transparency. And for the same reason that many arbitrations between investors and states are fundamentally ill-suited for non-public adjudication, so is mediation. And Amandine mentioned the Mauritius Convention and the transparency required in domestic legal systems when disputes involve governments. This is necessary for government accountability, respect for the rule of law, respect for citizen rights, and the actual, and I would emphasize, perceived legitimacy of the outcome. Of concern is that the confidentiality of mediated processes is a valuable process component in and of itself. Mediation rules have confidentiality as the default, absent agreement otherwise by the parties. Mediation could be used to move away from a purely rights-based adjudication to an interest-based format, as Robert highlighted, that could be participatory with and among other stakeholders, with some level of transparency early in the process being a key and critical starting point. And I've appreciated some of the ideas about transparency that have arisen during the course of this conference, and emphasize that it is of fundamental importance to the legitimacy of investor-state mediation. The second is participation. In the US, at least, domestic courts have recognized that negotiated settlements between a private sector actor and the government may significantly and negatively impact the rights and interests of non-parties. The US Chamber of Commerce devotes considerable attention to problems that arise when government agencies settle rather than defend lawsuits, because the ways in which these settlements may avoid legislatively established norms governing rulemaking, they may frustrate the separation of powers, and they may distort the duties of government agencies in favor of outside groups. Because mediated settlements may be more likely than arbitrations to produce non-monetary settlement outcomes, this can implement a state's contractual or regulatory arrangements and the rights and interests of non-parties. So in such circumstances, non-transparency and non-participation risk an outcome that was not informed by and responsive to those with a democratic interest or indeed right in the outcome of a dispute. So the third issue is the circumstances under and the processes by which governments can and should settle disputes with private actors. Again, in the domestic context, rules may apply prior to a settlement agreement being formed, which can include notice and comment periods open to the public. Some rules permit non-parties to a dispute the right to intervene and comment on or object to settlements. There are doctrines that require judicial approval of settlement agreements, and those that prevent the enforcement of settlement agreements that violate the law. Other mediation-specific rules to promote greater transparency or to have third-party review or acceptance of mediated outcomes before they are agreed or entered could be explored. And perhaps some of the reason why these issues of transparency and participation have been a persistent problem in ISDS are because in many, if not most cases, the investor in the state may have at least some interest in ensuring that the dispute is not public or not transparent, or that negotiated settlements are not set before and approved by domestic, judicial, or other bodies. And these same structural incentives remain present to the extent mediation is occurring under the framework and in the shadow of international investment agreements. So without fundamental adjustments to how commercial arbitrations are frequently conducted, a shift to investor-state mediation risks undercutting the important reforms that are being made in the ISDS context in areas of, in particular, transparency. So mediation, I do think, presents an alternative that is worthy of exploration precisely because it can be adapted by the parties to the circumstances of any particular investment-related issue. And in the dire economic context of COVID, this could be used to support longer-lasting outcomes. And it's a malleability that can be used to overcome the failures of ISDS. But to the extent these flexibilities are used to advance non-transparency, non-participation, or bypassing of legal norms that would otherwise be applicable to settlements with governments, it may be a case where the cure is worse than the disease, but I certainly hope not.
Fantastic, Brooke. Thank you very much. Sean, we'll turn it over to you.
Okay, thanks a lot. Thank you, Roland. Thanks to Bickle and the sponsors. I appreciate the opportunity. I am not a lawyer. I should say that up front. I'm trained as an economist and have had a career as a government economist, diplomat, and a trade negotiator. So I come from the U.S. Council for International Business, which is a major U.S. trade association. We represent U.S. business, represent our members in the UN system, in the ILO, and specific tripartite area of the OECD. And we are the US affiliate of the International Chamber of Commerce, which has an arbitration function. We have an active arbitration committee. Perhaps some people in the audience are involved in that, or your firms are. I come from the other side of USCIB, from the trade and investment policy side, representing our companies in issues. I've been active on the investor-state dispute settlement and investment agreement in a variety of international fora. So I just like to go back to basics as an economist. Sorry, apologies to the lawyers. Just point out that when we're not just talking about the details of provisions in an investment agreement. This is against the context of the shared need to really increase international investment, because it's investment that drives growth and jobs and all those good things that we need. And we need them especially now in the times of economic and health crisis that we're all facing. Domestic investments, public and private sector, is obviously an important part of the picture, but foreign direct investment, or FDI, is a very important element. It goes in all directions. We in the US get a lot of FDI now from China and India and Brazil and developing countries. It's not just a north to south kind of thing. And it's a fundamental tenet that foreign direct investment is inherently riskier than domestic investment. An investor is going outside of his or her home country, their established legal provisions, the culture, the politics that they know, and are putting themselves at risk under another sovereign government. International investment agreements, BITs, and investment chapters and free trade agreements are key to reducing that risk. From the investor perspective, there are two broad things that are important in investment agreements. One are strong, balanced, clear, transparent protections for investors. And then there's effective, second is the investment enforcement provisions, ISDS or otherwise. Some critics of ISDS promote a view that ISDS is just results from rapacious companies and lawyers scrounging around the world seeking to pounce on poor, innocent countries that are doing nothing wrong and just trying to extort exorbitant payments. I think that's a false model and should be rejected. The fact is that most companies are responsible. Most responsible companies see ISDS or disputes or cases as a last resort. When you invest, it's a fundamentally different relationship from a one-time trading relationship. It is a relationship over time. And to decide to go to war, the nuclear option, with the host government is something that investors are very hesitant to do. Companies do want to find a settlement, and they want to get out of the political spotlight that investment disputes often bring. Disputes are almost inevitable. The U.S. government is every year sued thousands of times in domestic courts by companies, foreign and domestic. It's just part of the game. I happen to believe that the ISDS system works. Doesn't work perfectly, but it can be a useful tool if it is balanced. And you know, as all of you know, as UNCTAD and others that do statistics have shown to us, governments win many more cases than they lose. The average award is a small percentage of what a claim is. The topic we were given talks about a potential surge in ISDS cases related to COVID or climate change. I don't know if we're going to see that. I don't know that the evidence shows that it is there, but I don't think we can necessarily accept that it is inevitable. Under the bilateral investment treaties and investment chapters that I know best, the US one, there is broad acceptance from the business community of the right to regulate for governments. Governments have to regulate responsibly. A right to regulate is not a right to discriminate, a right to abuse, a right to treat foreign investors unfairly. Will we get a surge in cases? I would say that depends on what the governments do, on how they regulate, how they act. And I don't see any evidence that companies are running around the world preparing to sue at the drop of a hat. So in this context, can mediation be a part of a solution? I hope so. I think it's a good idea. I'm not a lawyer. I'm not into all the details of it. But I think companies are going to be looking to, can mediation help them avoid costly ISDS cases? Can it speed up cases? Can it avoid long appeal processes? Can it reduce the cost? Can it perhaps depoliticize or get cases off the front pages of the newspaper? If so, that's certainly something business will be interested in. But from a business side, I think mediation has to be voluntary. It's only going to work if both parties want it. If somebody is dragged into a mandatory mediation that they're not committed to, I think it's inevitably going to fail. It must be seen as a support for a broader investment dispute settlement system, not as a substitute for it. It must be balanced, shouldn't be kind of put under some political thing, like, for example, the mediation, the results have to be reviewed by the Attorney General or the President or the Supreme Court of the country. That kind of tips the delicate balance between investor and state in an unfair way. The issue of exhaustion of remedies and how cases relate to domestic courts has been brought up by Amandine, and it's a complicated one. I think the word exhaustion has been put in this case for good reasons. I've served as a diplomat in countries in Africa and around the world where 6 and 8 and 10-year delays in court cases are not unknown. So I think that many in the business community that are very good citizens are strongly opposed, as am I, to this idea of mandatory exhaustion of local remedies before you could get into an ISDS system. I've been following, and as have many of you, some have been more involved than I, in the UNCITRAL effort to reform ISDS. I think there seem to be two basic options: the sort of let's go and deal with specific issues, incremental reforms here and there, or the EU-sponsored idea to let's kind of eliminate ISDS and start over with a government-dominated court system. I think that risks throwing the baby out with the bathwater, and so I think I'm a strong advocate of the incremental reform targeted on the areas that need reform. If that involves arbitrator selections or conflicts of interest, those areas should be focused on. But let's not lose what has worked well. So for me, the bottom line, and I think this is a business perspective, is on mediation. Yeah, let's use it. Let's try to use it more. It needs to be balanced between the two parties. It needs to be voluntary. It should be seen as another tool, as a prelude to the broader investment dispute settlement system, not as a substitute for ISDS. It needs to have effective enforcement provisions. So if you mediate a solution, it's going to be implemented, and it needs to be time limited. But thanks for the opportunity to contribute, and look forward to the Q&A. Thanks.
Great, John. Thanks very much. Wonderful presentations, all. Very, very thankful for all of those. So please, to the participants, feel free to submit any questions you have, and we'll try to work them in. Pending that, I will take the liberty, if I may, of posing a couple of questions to our panelists, just to get that kicked off. You know, it strikes me, obviously I come from the business side of things, the business perspective of things, and so it's, you know, for me in particular, it's great to hear these other, you know, perspectives are being brought to the table here. It seems clear to me, I guess, or apparent, that if we're going to think about using mediation as a way to expand the types of disputes that we might consider resolving to ones that involve, I'll say, greater societal issues, climate change, COVID, you know, resource consumption, et cetera, it does seem obvious that's only going to work, from the comments we heard, if we have some form of greater transparency and certainly participation from groups outside of both investor and governments, which is appropriate given the nature of those types of disputes. I guess my question to the panelists would be, if we were just, you know, starting from scratch and not looking to the existing models, you know, what would be your thoughts about what would be an appropriate level of transparency, recognizing that some level of negotiation does need to happen in private, where parties can really be stymied in what they might consider talking about? So how do you deal with the balance between having private negotiation settlement discussions, if you will, with the need to have some transparency for public purposes. And for participation, I can imagine, and Brooke and Amity, and you probably know this best, there's a range of potential participants who might come to the table. I don't see any reason why in mediation you couldn't have direct participation from representatives of the public, if you will. But how do you decide who's the right participant or range of participants to participate? Because, you know, mediation probably doesn't work if you have, you know, 50 participants involved. So how do you decide what's, you know, what's representative to make it, to get a sense that we have the right participation for the, I'll call it the public good, public interest side? Any thoughts from any and all, please? Brooke, you look like you're ready to say something.
I was waiting to see if anyone else did. I didn't write down your questions because I forgot to bring a pad and paper with me, but hopefully I can sort of remember. So I think as far as participation goes, I agree that other parties could participate. And I think there's a range of different ways in which parties can and should participate, and potentially, like in domestic courts, you see standards developed as to when and to what extent the rights and interests of another party will be at stake based on the outcome of a dispute. So for example, if it's a dispute over land, those are kind of the classic disputes, right? Where there may be a controversy involving third parties whose interest in land from a community or other perspective may be at stake. Those then you would have to deem, you know, either the claim could be reframed to not involve that, those rights or interests, or would have to be dismissed or put into a different forum. So, you know, domestic courts have grappled with these kinds of questions, and who has to be joined as a mandatory matter, who has the right to choose to join, you know, impleader and interpleader kind of doctrines in the US that have been developed to understand and assess the level of interest of third parties. Obviously, third parties can't assert their level of interest if they don't know the dispute is ongoing. So that's why I think transparency is such a critical prerequisite. In the context of mediation, you could also imagine circumstances, you know, and I know in discussions with Catherine and others, you know, labor disputes have incorporated some kinds of participatory or at least more public outcomes. But you could imagine, for example, where if a public interest issue were at stake, you could imagine bringing together sort of the broader public interest groups to say, for example, review a range of potential settlement outcomes that could occur, and give their input on those as to whether or not there would be other issues that might arise under each of those negotiated outcomes. Or, you know, before a settlement is reached, have the proposed settlement subject to public scrutiny for comment and feedback. You know, and again, these all depend, I think, on the range of interests and rights that are involved. But as far as both the actual and perceived legitimacy of the outcome could be important in some of these more public-facing kinds of disputes.
Robert, we'll start with you, and then Sean will come back to you if that's all right.
Thanks. I would endorse a lot of what Brooke said. And in some instances, I think it's in the interests of the business to enable a bit of transparency. If I take an example, let's say where there's a kind of dispute that Brooke talks about land or about access to water, having the community involved in knowing what's going on and maybe have some representatives there can actually help long run if the business is going to continue operating. Having them understand and engaged and hopefully part of whatever solution there is actually is very much in the interest of the business. If I can give you an example, there's, as you will undoubtedly know, this development that an understanding of an international standard of free, prior and informed consent for Indigenous people. Now, if we accept that as a standard, then where we're dealing with an issue where we have clearly an Indigenous land involved, then to have them able to engage early on in the process actually helps all parties, the state and the business, in going forward on it. So that I think there are ways in which it could be both possible and in the interests of the business community and the state for an ISDS where there is mediation as part of it in particular, which could be extremely helpful. So enables that element to be engaged with in a way which, if it rushes straight to the normal ISDS without the mediation as part of it, would not be easily able to be considered early on.
Great. Sean?
Thanks. No, I agree that transparency is a good thing. In the US, I think the US bilateral investment treaties were the first to begin offering some sort of transparency, and may not be enough to satisfy, but it is, I think it's part of good government. I think there are at least two legitimate reasons that you don't want to just hold the whole process, whether it's a ISDS hearing or a mediation session in a football stadium and let everybody just listen in. I mean, there are business sensitive information, prices and stuff like that could come up, that business confidential information. And the negotiators are just, if you want to mediate, or some things work better in private. So I think you've got to have some flexibility for certain parts of it to not be broadcast on television. I think there can be a downside to total transparency. It can lead to disputes getting more attention, getting politicized, getting demonstrators outside the door, or threats against people and stuff. So I think you need effective governance to control that part of the process. And then I think the question you raised, Roland, about who represents the public is a vexing one. I mean, there are a lot of great organizations out there, NGOs and business groups and public interest groups and indigenous people and so on. But just being self-appointed as we represent this or that, some of those are very political, some are not, some are government dominated behind the scenes, some are not. I don't know how you describe it, but I think you need to find some standards case by case to make sure that the groups that are given this kind of access into parts of it, are serious and responsible players. Thanks.
Great. Well, I'll, if I may, I'll just add in one quick perspective, and then Amadine will turn it over to you. So I just want to say, speaking again as one representative of the business community, I agree that I think I see plenty of room for transparency in this process. At the end of the day, if this is a contentious issue, it's going to be in the public press. There's going to be a lot of attention being brought to it anyway locally. Most global responsible companies don't want that. As Sean says, they're investing for the long haul. They want solid local relationships. They don't want the bad media. And so, because Robert noted, you'd probably rather be also, along with that message, that you're participating in some type of conciliatory process with multiple interest groups to try to reach resolution, as opposed to simply being on the bad end of the press only. How you carry that out, I think, is what we're the vexing challenge we're talking about. But it seems to me there's plenty of scope. Amadine, I think you had something you wanted to add.
Yeah, thank you, Roland. I think these are really two very interesting questions. I mean, both in terms of what do we require in terms of transparency and who among the stakeholders should be involved. And I think these questions, as Brooke mentioned, they are already answered by domestic court proceedings that have rules on transparency and public participation. There are also international standards. The Aarhus Convention on Access to Justice and Access to Information with regard to environmental issues also provides some answers. Because definitely one would need to go beyond only the victims or impacted stakeholders by a project. If, for example, environmental NGOs want to have, they'll say like us, we are not directly impacted, but we have an interest in participating, for example, in a dispute because we represent interest for the communities, but also the broader interests globally. And then also, I think it's interesting also in terms of transparency, yes, if disputes get politicized when it comes to critical environmental issues, well, that's what we call democracy as well. It's important to have those debates and those protests. So I don't really see it as an issue. I think it's a requirement from an environmental perspective. Yeah, so I think I will stop here. Thanks.
Great, thank you. Anyone add to any of that? We've got a couple of questions from the group, which I'll pose. The first question offered to us is whether or not the U.S.-Mexico Canada agreement, and particularly its chapter on the environment, might provide an opportunity or a model for us to consider when we're talking about the civil society being involved in getting to a less contentious outcome. I don't know if that's something anybody's had a chance to look at, but interested to know whether that might help address some of the asymmetry and environmental damages arguments or other environmental concerns, but also whether it might be a model in other areas. So is anybody on our panel familiar with the those components of the U.S.-Mexico-Canadian agreement? All right, doesn't sound like it is. Next question we have, in a recent conference, a number of German and Dutch representatives at least indicated that their opinion or view was that any COVID-related claims would be covered by the regulatory space in their investment arbitration agreements. What does the panel think about that? And if we're skeptical of using the IIAs as a means to address COVID claims, are there alternatives, and could mediation be used to help find a common ground, particularly given that all states have been affected?
Sure, I can take a stab at that. I actually have that UNCTAD conference recording on my to-watch list, so I can't speak from having watched it. But I do think part of the concern here, and you see that when speaking or looking at sort of under which treaties are investment claims coming, it is oftentimes, which UNCTAD has done a lot of work on, these very old generation treaties, many of which do not have regulatory space, or have very limited regulatory space, or to the contrary, have very expansive substantive protections. So to the extent you have newer treaties that have broader regulatory space, smaller substantive protections, and perhaps more procedural, USMCA, for example, domestic exhaustion requirements, or other kinds of cooling off periods, which cooling off is in a lot of treaties. But anyway, I think it's the whole combination of the treaty that we really have to be considering. And I do agree that, and this has been something, discussed in sort of a lot of these COVID-related discussions lately, that the regulatory space in newer treaties in particular may be sufficient for governments to adequately defend against these actions, particularly if taken in a non-discriminatory way. But that still doesn't preclude, I think, concerns to some extent about, the expense of defending the claims, regulatory chill, and those other issues. So I do think there is uncertainty linked to the broader uncertainty and criticisms of ISDS in general. And so I do think that mediation could help to find a common ground in these areas. And again, though, I think the broader public interest would just want to ensure that when governments are taking actions like nationalizing hospitals temporarily, as Spain has done, or imposing import or export restrictions, as many countries have done to secure food supplies or medical supplies, that others see that process unfolding and participate when and if they are impacted. So yes, I do agree. I think a part of the problem is these very old treaties that are still existing. And to that end, termination or withdrawal of consent could be an answer under COVID. And one thing that I know has also been discussed under COVID is actually suspending, in particular, older treaties in this context, suspending under the Vienna Convention.
Robert, please.
I'll just add a quick point, which is that, of course, there are many instances where COVID affects, as Brooke says, some matters which are very broad in terms of what a state might, how the state might act, as, for example, Spain nationalising hospitals. And the existing case law, of course, has shown that there's a lot of resistance to arbitrators going beyond what is seen as their remit, such as in the Obasa case of saying, well, here's a human right about water, let's be very careful on that. And that received a lot of condemnation. So it almost, I would like to suspect, it proves that, or shows and indicates maybe that arbitration is very difficult under that kind of method, under the existing ISDS, to try and deal with aspects such as COVID, because there is a great deal of difficulty in trying to engage on these issues within quite rigid and limited bounds available to an arbitrator. So I see mediation as, yes, offering a possibility which can take it in a different direction, in perhaps a different way of looking at it. And then just to pick up an earlier point made about treaties, of course, sometimes there are ways forward. In the TRIPS agreement, they led to the Doha Declaration to deal with the AIDS crisis. So sometimes there are ways forward, though that was a multilateral treaty. These are, of course, are bilateral. So there are occasional ways forward, but I think the existing framework for ISDS makes it quite difficult for most of the particular examples to deal with COVID in any broad sense.
John, go ahead.
Thanks, Roland. I agree with much of what's been said. What are we, 8 or 9 months into the COVID crisis? Governments have been taking actions, issuing policies, and I'm not aware that we've faced a deluge of ISDS suits or something. I think the business community generally has acted responsibly and realized, and I think the governments have generally done things in a non-discriminatory, appropriate kind of a way. So, I mean, we need to be alert. I guess I, as a business person, would be hesitant to give a carte blanche that says, in effect, well, if it's a COVID-related thing, then you can do anything. You can discriminate and take any arbitrary action, because then you're going to end up creating another set of disputes about what's COVID related and what's not COVID related, and you're just transforming it to a different level. But I think if people act responsibly, I think mediation may be particularly appropriate if, as we all hope, there's an endpoint to at least the worst aspects of the COVID thing, so that, you know, it's immediate, get through it and get back to a more normal basis. Thanks. Great,
thanks, Sean. I've now been told that I guess our questioners can talk to us live, which I didn't appreciate previously. So my apologies to the prior questioners that I invoked the liberty to ask the question for you. But our next question comes from Dr. Heidemann. Doctor, I think you're on mute, please.
Thank you very much. I just had a thought on Mr. Donnelly's comments. Foreign investment is sometimes not very good for the states when it causes great damage there in some instances. And therefore, there is a very legitimate reason to have the third parties maybe involved to settle claims. So there's a very broad range of cases, potential interests. And my question would be, how can we define the level of legitimate representation of these, what you call the self-assigned representation groups, NGOs, interest groups, which I find a very valid point. So could we have a process of assigning, for example, for Client Earth, how do we decide who is really representing the public, except for the parliament, of course? elected parliament?
Yeah, I think it's really a valid questions. I think it very much depends on the case and the interest ethics and the circumstances. One also needs to know that usually organizations do work together on those kind of issues. So usually the local communities would work with the local NGOs, and sometimes you have an umbrella organization or larger group that will join forces. But I think how to define depends very much on the interest at stake, as I mentioned earlier, and how much it's been impacted. So yeah, I don't know if I can really answer precisely to your questions, because it really depends on the circumstances.
Yeah, thank you. But I think that's something to work on.
But yeah, as I said, there are rules on the domestic proceedings as well, and there are international standards that are there to identify the interest and the impacted stakeholders and the victims. So yeah, but that's the same when we apply, when we want to have standing before national court. We also have to fulfill those standing requirements.
Sean, I think you had something you wanted to add?
Yeah, thanks. Since I raised that question originally, I don't have the answer, but I think it's going to be very hard to lay down criteria and so on like that. I think it's going to have to be sort of case by case, and hopefully there's some equivalent to the national court or somebody. I would hope that it not be the government, which might be the party in the dispute or something, but that if that can just apply common sense and say, well, this organization's been around for 30 years. It's got 20 million members. It's stood the test of time. It's a little more serious than this one that was just created yesterday and may just be a front for the pharmaceutical industry or for something or other. But how you spell that out, I think you have to find a way to, in the specific case, find the ones that have real legitimacy, international or domestic, but that's going to be agonizing kinds of decisions.
What do our panelists think? Is there a role for the mediator, an experienced mediator, to help decide which organization should be heard, or maybe the manner in which other organizations who don't have a direct seat at the table might be heard? I was pretty intrigued by I can't remember, I think Brooke, you might have said the sort of review and comment kind of public notice, or maybe Amadina, it was you, some equivalency, if you will, of sort of review and comment maybe that might be made to other groups about a range of settlement options. But what if folks think about, the mediator playing at least some role, maybe not the only role, maybe not the definitive role, but to try to help figure out who should be there to create legitimacy for the outcome?
If I might jump in, sorry, I had my mic off mute, so I will. I think that's an important and valid consideration, and something that is also raised by the flexibility of mediation. One thing that has come up, and I haven't heard it raised in this conference, and maybe I missed it. If so, apologies. But one thing then that I think that is important is, who is the mediator? Because obviously in investor-state arbitration, and I mean that in the very broad sense, in investor-state arbitration, there is currently a lot of criticism leveled at, sort of this very Western and bias of, or not bias, but, the diversity, I guess you'd say, of who arbitrators are. And I think that then becomes very important too, when you're thinking about who a mediator is, the role of the mediator in deciding who should participate, or identifying and doing research on identifying who might have an interest in the case. So I do think it's important, and is a good way in which mediation could be more flexible. And I don't raise these as criticisms, merely questions for consideration.
Robert, we'll go to you next, but just real quick, a brief interlude here for our participants. We don't have any other pending questions, so we're going to keep chatting about what we want to chat about, unless you have questions you want to pose. So please pose any that are on your mind in the last 5 minutes we have. But Robert, go ahead.
I was just going to add to Brooke's comment that I think the media has a surprising amount of flexibility. It could be, for example, during the course of mediation to request one or more parties to engage with those in their communities, for example, or maybe in a business sector before responding to the next stage of mediation, which is available mediation, less so in other forms of dispute resolution. And I think that is feasible. It can also raise cultural issues. Certainly there's been mediations where there is a big dispute about who represents which group. That happens, of course, in cases as well. But sometimes it can arise in issues like, well, women may not be represented at all in a particular mediation. What do we do about that? And the mediator can be quite constructive on that to ensure that there is some engagement in whatever process, as well as appropriate interpretation, because we so often think, well, the way we've decided is the way it'll be spoken. But I've been involved in one where there was very different ranges of linguistic ability, and being alert to that is very, very important, because you can get very different outcomes if you decide that you're just going to go with perhaps the majority language in the country, which may not be the majority language in the region in which the particular issue has arisen. Thank you.
Great, thank you. With the couple minutes we have left, I'll pose one more question to our group. I think the other issue that
I'm not sure we have more time.
Oh, all right, no problem.
So sorry about that.
We were happy to keep going, but we're happy to stop as well. Let me thank all of our panelists for terrific insights and a range of really interesting range of views. So thank you.
Fantastic. Thank you.
Thank you very much, Roland, for moderating.
So this is the moment where this is when we usually ask everyone to go and enjoy the libation. But in this instance, I need to be careful as a Muslim myself to say something like that on the record, but you get the hint. I think we are going to hopefully not lose our speaker on this panel, but we're going to have Sir David Edward. So I'm going to ask Liam, who's been absolutely wonderful with helping us sort out this conference and making it such a success, along with Yarek and Wolf and Maxi. I want to introduce the Right Honorable Sir David Edward. He's the Vice President of the British Institute for International and Comparative Law. Sir David Edward practiced as an advocate in Scotland and was appointed Queen's Counsel in 1974. He was president of the Council of Bars of the European Community in 1978 to 1980. Professor of European Institutions at Edinburgh University, 1985 to 89, and now Professor Emeritus. He is judge of the European Court of First Instance, or rather he was from 1989 to 1992, and of the European Court of Justice from 1992 to 2004. He sat part-time as a judge of the Scottish Appeal Court from 2004 to 2009, and he is an ICSID arbitrator, a member of Blackstone Chambers Temple in London. Liam, will you kindly promote Sir David? And by no means demote our panelists, but I'll leave to you the magic.
Sir David is connected.
Yeah. Would you like me to speak now?
Sir David, very good to see you. You're in Edinburgh.
I'm in Edinburgh, yeah.
Yes, and I because I was supposed to be in Scotland and I couldn't, I decided to wear my tartan just to emphasize that place and space and time could be breached. How are you?
I'm fine, yeah. It's cold, but
yes.
Yeah.
I hope you managed to see some of the conversations that took place.
Yeah, I watched Meg Kinnear yesterday, and I've listened all afternoon. So I do. Would you like me to give some comments now?
Absolutely.
Right.
Absolutely. Please do.
it occurred to me as a way of analyzing this problem. First of all, there's an immediate problem of COVID, and the consensus appears to be that COVID is not as much of a problem in this context as in others. I don't know whether that's true. My view of COVID has been more particularly that it does raise questions, particularly in the European Union context, of enforcement of competition rules, where it's clear that there has been cooperation between undertakings which might not be normally permitted under the competition rules. And there's also the danger of creating a number of dominant positions, particularly in producers and suppliers of vaccines. That's a problem, and that doesn't seem to be highly important in this context. Very important in this context and in most other contexts is climate change and environmental considerations generally. And the most obvious point that comes out of that, I think, is the need for any system to make it possible for wider interests to take part, particularly the representatives of civil society and so on. But that does correspondingly create a problem as to how you choose who is going to be able to take part. And I would imagine also whether the arbitrator or mediator is in a position to direct who shall take part, to direct who shall cooperate with each other under a single umbrella, and so on. These are problems and they're there. But more in the long term and more generally, I think we are faced with something that I've observed really happening throughout my professional career, which started in 1960. That is the move away from the notion of adversary justice. Now, that doesn't necessarily mean a move away from the use of courts. And we can see that in the reaction of the European Union to ISDS, the desire to create an investment court. I must say that seems to me to be pie in the sky, but that is an illustration that the circle will go around and come back perhaps to the idea that courts are a good thing and judges are perhaps the best people to deal with particular problems. That is an issue, but it's an issue also, I would suspect that the real problem is whether you are moving away from adversary justice and the kind of expectation of binary solutions, you win, you lose. It's not necessarily true that courts operate in that kind of way. And indeed, in my own experience in the European Court, in dealing with preliminary references on points of law, you really are not concerned with who wins, who loses much of the time at all. There is obviously a move against ISDS in its customary form. And as we move, if you are moving away from judicial solutions and arbitral solutions like ISDS in the conventional system, then where do you end? You necessarily, I think, probably end in some form of arbitration, as mediation as the solution. And there is, I think, it is highly desirable, and it is happening, that there should be a core of people who are more than just ad hoc mediators. They have experience and training and a full understanding of what is involved. And that, I think, is fundamental to the operation of mediation, which after all depends ultimately on consent. If you have to consent to mediation, and you have to, throughout the process, accept what the mediator suggests. But of course, the mediator is not a judge and is not expected to make, is neither a judge nor an arbitrator, or he, I apologize, I should have said he or she is not a judge or an arbitrator. Or indeed an umpire who wins, who loses. It's a quite different skill, I think, to work with people and work in this context with a very large number, potentially a very large number of people, towards an amicable solution which everyone is willing to accept, even if they don't entirely agree with it. I think that's, well, one other point which has not been mentioned. There are, in my experience, there can be a problem where there is an allegation of corruption. And I don't know how a mediator copes with that, because in judicial or arbitral context, you can have a firm decision that a party is excluded from a remedy because of corruption. I don't quite know how you deal with that in the context of mediation. And another point that has not been mentioned, as far as I remember, is change of government. The possibility that you have a change of from the government that originally entered into the mediation idea, a change and perhaps a very stark doctrinal change between one government and another. And the question is, will the willingness to submit, to take part in mediation continue if the government changes? Those are my immediate thoughts.
Thank you very much for this really insightful comments. And I will ask my colleagues, what I'll do is I have a couple of discussion points that I want to raise with you, just following from your comments. And then I'll ask colleagues to raise their hand if they want to offer any sort of questions or comments. And we'll probably wrap up end the day with having Wolf and Jarek say a few words. So with that in mind, I want to start, Sir David, with this point about your career, and especially in the European project, in the European community. Supposedly, there was this kind of concession, or this idea that a judge from a different country in Europe who would be sitting in the court is also some form of a both, I wouldn't call it a sovereign, both a sovereign act, but it's also a diplomatic one. And my experience, the way I got into working with ISDS, and here's the context, is the closest approximation was the UN Mediation Support Unit, which is dealing specifically with state-state conflicts and so on. It seems to me that the issue there is much clearer, in the sense that you have a mandate, you have, as a mediator, some immunity is offered by the law, but you don't have something equal to that. There is no real delegation that offers you this experience. So that's my first point. I don't know if you want to address that first, and then I was going to talk about the situation with the court, so I'll ask that second one as well, which in my view, it goes back to your point about climate change. I think what tested our capacity in Europe to really understand the limitations of the system was all of the cases that came out of renewable energy projects. And obviously, I kind of go back to one of the points that one of our colleagues mentioned, that expediency is important, because if we have projects that are delayed, we won't meet sustainable development goals. We won't transition to renewable energy. But that seemed based on looking at, Spain, Italy, and so on and so forth. Even the Energy Charter Treaty, who sort of really paved the way, understanding that background, couldn't seem to move things towards the right direction. And somehow now it's up to a mediator who's starting to say, let's bring both parties together. We're getting lost in conversations like access to justice. Not that that's not important, but I'm not sure that the function of mediation is necessarily to offer justice. But that's my own personal view. So perhaps just to come back, it's my point is about why has the European experiment led us to the idea of a court, a singular authority? And secondly, if we know for a fact that we really need to go ahead with these projects and it is in our interest that they move forward, why can't we come up with some sort of authority, legitimacy, diplomatic mandate to deal with these problems?
Well, let me begin with what I think was part of the point you started with, which is a multinational institution and multinational arbitral panels. My experience has been that I really ceased to notice the nationality of the people I was working with. What I did notice in the European court, of course, was the difference in attitude, which is of lawyers, because lawyers are always, to some extent, the children of their legal education, their legal upbringing. And it is very clear. For example, the clear distinction between public law and private law exists in some countries and is part of the mind state of the lawyers. If you are a public lawyer, you probably know very little. In some countries, you probably know very little about private law. And correspondingly, if you're a private lawyer, and particularly if you're a common lawyer, the idea of public law as a legal system quite different from the private law system is rather foreign, and you have to get used to it. That's what I found more important to get over, I think, and I've seen it equally in arbitration. On the second, what was the second point?
The second one is about when we finally got to a critical mass with the Energy Charter Treaty mediation efforts. That ended up upsetting a lot of countries, I think. So we need to be able to act fast with the renewable energy projects that affect climate change.
I think that is obviously true. And the problem is that any form of legal process is liable to move slowly or less fast than is desirable. And therefore, perhaps this illustrates a potential advantage of mediation, because it can move at the speed of the willingness of the parties. But I have to say with regret that my experience is that however much you put pressure on parties to proceed, they don't actually do it very often at any speed at all. And the party attitudes are a hindrance to speedy resolution.
Yeah,
but
I have a
bad.
Sorry, go ahead.
That's the bad side.
Yeah, I have one hand raised by Professor Kizjian, so I'll ask her to please share her thoughts. Hello.
Hello, very nice to see you. Sir
Nice
David, very nice to see you. We met a long time ago, so you probably do not remember. What I would like to-
Where did we meet? Where?
We met in the context of the ILA, the International Law Association.
Gosh, yeah.
Sorry about that. What I would like to do in 1 or 2 minutes is actually look at the program. We are supposed to discuss next steps. And I want to disclose the fact that being part of the academic forum, which is helping the Secretariat of UNCITRAL within the negotiation of the reform of ISDS, I am very concerned that we should really look at what is missing in terms of studies and data that we have not been able to gather so far. I don't see Alejandro anymore on the screen, but he has been doing within the Energy Charter Treaty, he has been doing some mapping of domestic law on the impediments faced by states and administrative authorities to mediate. And I would like to ask you, Sir David, if you have had experience with states showing their own domestic law as the basis for the impediment for mediation and negotiation. Because if that, I mean, in all the interviews that I've been conducting for the past 2 years or so, a lot of states have told me, we cannot mediate, we cannot compromise, you know, but they don't show me exactly where is the source of that problem. So I think the next step is actually to map out precisely domestic law of states. And the second, and I will stop there, but the second study or thoughts or discussion perhaps that I would like to see happening is what we call mixed mode. The American milieu in arbitration and mediation has been very high on proposing those mixed mode, using both arbitration and mediation, court and mediation, to have a holistic approach to dispute resolution and what you called going away from adversary justice, but including mediation within the adversary system and making it to work with mediation. Does that make sense at all?
It does to me, just very brief answers. I personally find it extremely interesting the way in which, having been brought up on adversary litigation, because I started life doing personal injury litigation, which was absolutely straightforward litigation, where one party won and the other lost. Moving the whole system of dispute resolution has changed totally, and all the potential ways of doing things are now out there and available for choice. It is true, I suppose, that legal process is not one of the is not one of the topics to which academic lawyers generally go as their forte, what they're discussing, and I think what you're suggesting is that there's a lack of, as you put it, holistic look at this problem. Now, I've forgotten the first point that you made.
I was saying that we need mapping of the real sources of the impediments that states and public authorities are saying that they cannot mediate.
I think that is, the source of that is probably a question of not that the state cannot mediate, but that they are not in a position to mediate on behalf of the state and bind the state. I'm not clear in what, I suppose, if you look at international arbitration, you get for ISDS arbitration, you find your source in the BIT, in the bilateral or whatever investment treaty or whatever. That is the source of the obligation of the state to take part. And I suppose you're probably right that in the absence of that international law commitment of the state beforehand, it then becomes very difficult for an official of the state to say, I am going to take part in this and my part will bind the state.
Thank you so much for that explanation. And I think it seems like we are coming back to this idea of a mandate or some sort of a raison d'etre, I think, for mediators to do what they need to do. We have a bit of a time. I know that everyone's being promoted into the Zoom call and I want to see your videos. Hopefully we'll see you soon. But if you have a question or a point that you want to raise, can you just press hand up, please, so that I can call on you? Or, you know, just comments are even fine, but we have this huge opportunity with Sir David. And had we done this, not with BICL, with the World Economic Forum as we were thinking, but BICL has been absolutely wonderful, we would be having a fireside chat with a stiff drink. Any hands? I'm not seeing. There we go. Now I'm seeing them. And I suspect it's in the participants list. Well, it's wonderful to see everyone. Well, I'm going to ask Mark Appel since he's always a practical mediator. Right, go ahead, Mark.
Thanks, thanks, Malik. Can you hear me okay? I guess I should check that. Yes?
Yes.
I think the Catherine really put her finger on an issue that has been raised and raised and raised during the course of this conference. And I think one of the takeaways, clearly Alejandro raised it in his own remarks and has maybe among us taken the greatest steps to address it. And that is, how do we make it easy for public officials to use, to embrace the mediation process without fear? Yeah, without fear. And fear has been a word that we've used. Barry, you used it in your remarks. I've written on the, you know, it comes out of our Singapore University study, you know, multiple fears. If it is too hard to do, people won't do it. And so accessing mediation without danger, maybe it is domestic legal frameworks, maybe it's other things. And then I want to say something else, because I think it's another takeaway, and selfishly I need to leave for another appointment shortly. And that is to say that we also need to make it easy to succeed. And my other takeaway from this conference, and big takeaway for me, was that whatever we can do to promote earlier access to the process. Ken, you talked about it in your comments. I think all kinds of people have mentioned it in their comments. I thought it was very poignantly raised today by the civil society participants in the call. I think the time to involve people, it was raised by our business colleagues. The time when there is more currency available is early. So I'll stop there. Those are my sort of two comments.
Thank you, Mark. Does anyone have any other comments? Okay, I'll ask James South.
Sorry, Malak, I couldn't work out how to put my virtual hand up, so
I know, I gave up. All right.
I just wanted to maybe just pick up, as I think Catherine, was it Catherine? I'm sorry, I don't see your first name, but Catherine's point. And caution a little bit about focusing too much more in on academic studies. I mean, I think I understand why that's necessary, but in my view, the sort of conditions are there, and there just needs to be more work focused on the practical aspects of this, rather than navel gazing too much in research, because often that's, while it's illuminating, practically it doesn't help us to move things forward. And I think we've discussed, we've got the institutions and the process changes, we've got the capacity building happening, we're doing the awareness raising with the states, and listening to Mercedes today, there's some mediations happening. So we should build on that practical experience rather than going back too much into academic discussions at this point, in my view, to really move things forward.
Thank you, James. Ian Forrester.
Hi, I'm speaking from Luxembourg, and it's an extraordinary and pleasant reversal of my previous geography, where David was a judge in Luxembourg and I lived in Edinburgh. So my question, in a sense, is a little bit philosophical, but it's also concrete. We've been talking all this afternoon about ways of deformalizing the resolution of investment disputes. Now, and all those arguments are very, very interesting. On the other hand, the European Court, of which David used to be a member, has shown intermittently certain skepticism about arbitration because, and I'm putting it crudely, the court doesn't like rivals in interpreting European law. And so one of the fears, concerns that's reflected in the Achmea judgment is that arbitral panels won't, and I'm speaking formal arbitral panels, won't respect European law correctly or on the lines as the European Court. I wonder, and so you can see the tension. 27 member states, Europe's a big economy. I wonder if David has any thoughts, concerns about where we may go with the line of Achmea judgment.
Shall I? Let me say, first of all, in answer to James South, my experience was I went from being a litigating lawyer to being a professor of European law. And the difference lay in this, that as a professor, I had to condense my experience, so to speak, and my knowledge into a form in which it was deliverable to students. So, and that meant a kind of bringing together. I couldn't operate in compartments because I had to, and this was in the days when European law was a relatively early in early development, but I had to give it some structure. And I think that is the particular contribution that academic study can make, giving the topic some structure. And on the question of the courts and arbitration, the attitude of courts, it is certainly true that the European Court in particular has shown a marked and, in my view, mistaken hostility to arbitration. It doesn't seem to me to advance matters at all if arbitration is set up in competition with the courts. Nor do I believe that the court of one particular system can claim total autonomy in any dispute involving any subject of that jurisdiction. It seems to me to be a claim beyond the recognition of international law as going beyond any particular single national or in the European case, regional jurisdiction.
Malik, sorry, and the point that, I think Ian raised, I don't know if that's something that, Jarek, sorry.
Oh, I was just going to say, we only have around 10 minutes left before the end. And
yeah, but I'm impressed with the fact that we have everyone still here.
Remarks. But the idea, what we're hoping to achieve by this group discussion is to have some brainstorming on what we can do next. I'm also a member, by the way, of the academic forum. And I think what makes BICL different from the academic forum and from other institutions is that we try to merge academics and practitioners and government officials. So if anyone has any good ideas how we can take it forward, be it conducting studies or trainings or doing more lobbying work, then I think it's a good moment to discuss it now, if you don't mind, Malik.
I will. I just want to give Anne the opportunity to make a comment because she's been raising her hand, and then I'll...
Yeah. Thank you. I didn't think in the line what Jarek now said concerning more lobbying or things like that. What I think we need to think about is, I mean, if we look at mediation as some sort of, not replacement, not substitute, but going alongside, I think we would need to take care that, and we have discussed all the stakeholders, NGOs, states, and also business concerns, but I think if we look at the points raised, why now we have the UNCITRAL Working Group 3, so things like diversity of arbitrators, like diversity of mediators, we need to think about. We need to think about, what about inconsistency of settlements, substantively viewed? So if you look at all those issues which were raised by the stakeholders, we would actually need to do exactly the same exercise for mediation. Because the arbitration is still the benchmark, and you need to show whether or not mediation will fare better or not on those criteria, because otherwise we are going nowhere, right? So I think that is an issue which would need to be discussed in the future, and maybe on those different points which were raised by the states, as well as the academic forum, by the way.
Right.
Thanks.
Wolf, shall I give you a moment to tell us about the ISDS task force, the working group, and where it started, where it's going, and whether or not this is an opportunity that we've been really creating critical mass, beginning from Harvard to BICL and hopefully China and Singapore next year?
Right. Well, first of all, may I just thank everybody who participated in this, both as speakers and simply as participants, because I think this event has been quite extraordinary, and all of the speakers and the discussions that have taken place have led us, I think, to further what we started at Harvard, and that is really looking at how mediation can play a role in ISDS and how to overcome many of these obstacles that I think everybody has very well highlighted over the last 2 days. So we did create a working group made up of people who participated at Harvard last year. And I think given the new people that have joined this year, we'll also invite you to the working group, which is really meant to continue this discussion and on some of the points that you just raised, for us to have a forum in which to have a more in-depth view of some of the matters that were discussed here the last 2 days. So look towards that working group to perhaps continue some of these discussions and address some of the things, Catherine, that you were raising as well. I think, you know, just my own view coming out of this over the last 2 days is clearly there was a perception from all stakeholders, and I'm really glad that we had a very broad range of stakeholders, that mediation does have a role to play in ISDS disputes. But there clearly are obstacles that have to be addressed. And I think that's what we have to continue to look at. There are clearly some key concerns that also have to be taken into account. I think the transparency versus confidentiality question is a very important one. And there are different ways of perhaps addressing that, as we heard from Brooke as well. But that's an area that we do have to take a closer look at, as well as third-party participation. And that's something I know we with James and ICSID have also been looking at, is really how do we bring third parties into the mediation process in a way that arbitration or certainly litigation could not do, and provide that forum that people have been discussing for third parties, but identifying, you know, who those third parties are, and stakeholder mapping really that we also discussed as who represents these various interests is part of that. We have to continue with our capacity building, which everybody I think has recognized as being essential. We need people who are credible as mediators, who have an understanding for the ISDS process as well as mediation, so that people have faith in and trust in the people who are actually mediating. Otherwise, this is not going to work at all. And we have to continue to discuss with stakeholders their interests and how those can be met in order to have mediations actually take place. And it was interesting hearing Mercedes today, who I know very well as an international mediator, expressing her view that it's the mediation process and mediator skills that are essential here, as it is in any mediation. This is another form of mediation, which has its own, of course, peculiar aspects that have to be addressed. But it still comes down to mediation fundamentals at the end of the day. So that was also interesting. So those are my comments, I guess. And we'd really be interested, and I think all of us, Jarek and myself and Malik, to hear from all of you. If you have ideas, you know, send us those by email, and we will have a meeting of the task force shortly in the future, maybe to start looking at where we can take this and where we might have a similar type of forum to this one next year, because we would like to continue this discussion in a forum every year.
I just thank you, Wolf, for making the explanations about the ISDS working group. And I just want to thank Sir David for his patience and giving us the time to hear where mediators are. And I think that there's a lot of good faith and effort that everyone has been putting here. We just want solutions. I also want to thank Jarek a lot for being also patient with us and giving us the international, the treaty forum as a platform, as a supporter, as really a champion. And we look forward to the collaboration. And he's joined the task force. And what I would say is, I'll leave it with one point before I hand it over to Jarek, which is, we've been talking about Europe, but we really do need to keep an eye on what's going on in China. I do think the translation issue, the cultural element, our disregard of this point about harmony may be harmful more than anything. And we are, thanks to the leadership of James, we're having discussions about how we get involved in different ways. So hopefully all of you can be credentialed by James and IMI, and maybe that's an experiment. In the end of the day, it's, as was said, it's not about theory. It really is, we need a pilot. It's not a theory. It's just, we need to keep at it. So thank you so much. Thank you, Sir David. And Jarek, over to you.
Thanks, Malik. I think we managed to make two worlds overlap, the world of mediation professionals and the world of ISDS specialists. And I think that's a great achievement because mediators need to learn from ISDS experts, and ISDS experts need to learn from mediators. And I think the level of discussions was very high. The questions from the audience were exceptionally good. And we will publish a video of this event later on, so that not only those 100 something people who joined us, but also the broader community of people interested in mediation and ISDS will be able to benefit from these discussions. And I would encourage you to follow BICL on social networks, because we organize other events about dispute resolution, about ISDS, about all sorts of things. And I hope to see many of you as attendees and as speakers, and look forward to collaborating with you in the future. So thanks again. Thanks, Wolf. Thanks, Malik. Thanks to the BICL team. And I hope to see you at other venues.